Officers, are you ready to go live?
Yes, thank you.
Okay. I'm Councillor Janet Evans, and I will be chairing this meeting. The committee for this hearing comprises Councillor Marie-Therese Rossi, Councillor Toby Benton, and me. We are joined by David Williams from the Council's licensing team. Our legal officer, Lindsay Lemassurier. Also with us is our committee officers, Holly Weaver, Jerome Treherne, and Tommy Hamner. Before we start the hearing for this case, just a few ground rules. Please keep your microphones on mute until you are invited to speak, as only 2 mics can be used at one time. And please make sure mobile phones are on silent. Thank you. The case before us today is to grant a license for World's End Public House, 459 Kings Road, London, SW10 OLR. I can confirm that I have no declaration of interest to make regarding this item. Do the other members have any declarations to make?
No declaration to make.
No declaration, Chair.
Thank you. Procedure. For clarity, I will briefly outline the procedure of the meeting, which has already been circulated with the papers. First, the licensing officer, Mr. Williams. I won't call you Williams. We all know who that is, David Williams. So, okay, we'll give a brief outline of the application. Please, could you confirm your attendance?
I'm here, Chair.
Thank you. Then I will ask the applicant's legal advisor, Mr. Alex Green, to present his submission. He will have up to a maximum of 10 minutes to do so. He is joined by his client, Mr. Ian Knight, who may be able to assist members should they have any questions. Please, could you both confirm your attendance?
Afternoon, Chair. Alex Green, Gosjobs. I'm here. Thank you.
Thank you.
Afternoon, Chair. Ian Knight from Wellington Pub Company.
Thank you. Then questions may be asked by members of the committee of the applicant, followed by questions from the legal officer. There are no objectors here, correct?
Correct. Thank you, Chair.
Thank you. After this, we'll ask our legal officer, Ms. Lemassurier, to lead on the draft conditions session. The list of potential conditions has been circulated to all of the parties prior to the hearing. Please, could you confirm your attendance?
Present, Chair.
Thank you. Then finally, we will turn to the government's team to see if any issues have been raised that we need to consider. Oh, here you are. There will be no summing up and the meeting will end. I would like to remind everyone that the committee has read the papers which comprise the main pack and one additional submission that has been circulated to the parties. So there is no need to repeat their content, but please do draw our attention to certain points and pages. Let's get going. Mr. Williams, please can you outline the case for us and advise if there has been any additional documentation received?
Thank you, Chair. Good afternoon, everyone. Today's application has been submitted by Wellington Pub Company plc for the grant of a new premises licence in respect to World's End Public House at 459 Kings Road, London, SW10 0LR. The premises has previously benefited from a premises licence which has now lapsed. The licensable activities and times of that licence are shown in the table at pages 6 to 8 of today's main bundle. The applicant is seeking the grant of a new premises licence to permit for all floors sale by retail of alcohol on the premises Sunday to Thursday 1100 hours to 2300 hours, Friday and Saturday 1100 hours to midnight. Provision of late night refreshment indoors Friday and Saturday 2300 hours to midnight. There's actually a typo on page 7 that says Sunday, but it is actually Friday and Saturday. Also the exhibition of a film indoors Sunday to Thursday 1100 to 2300 and Friday and Saturday 1100 to 2400. Also another typo on page 7 that says Sunday, but should read Saturday. The performance of both live and recorded music, Sunday to Thursday, 1100 to 2300 hours, Friday and Saturday, 1100 hours to midnight. These are of course deregulated up until 2300 hours. The proposed operating hours for are Sunday to Thursday, 1100 hours to 2330 hours, and Friday and Saturday, 1100 hours to 0030 hours. The licensing authority has received 14 representations from residents, one of which was withdrawn in respect to the application. A summary of the remaining 13 representations, including one from 10 Acres Residents Association, can be found on pages 11 and 12 of the main bundle, and a copy of the full representations can be found at Appendix D. Council records show that at the time of this report was written, 4 noise complaints had been received in the preceding 24 months, details of which are attached at Appendix E. There have been no temporary event notices submitted in the past 12 months, and there are no planning restrictions or conditions which a subcommittee should be aware of. Other than the list of proposed conditions that are to be considered if the committee were minded to grant the application, there have been 2 additional documents, one with the applicant's submissions and one from an objector today. That concludes my summary of today's application, Chair.
Thank you very much. Now for the applicant's case. Mr. Green, please can you advise if there have been any amendments to your application?
Only the amendment that you should all be already aware of, Chair, which is the reduction of the hours drastically down to the hours that have been mentioned. Nothing else has changed, Chair.
Thank you. Please can you now present your submission? You have up to 10 minutes to do so.
Thank you, Chair. Good afternoon. I'll go through my submissions in 3 stages, if that's okay. Firstly, I'll explain why we're here today. Secondly, I will demonstrate how the application promotes the licensing objectives. And then finally, I will quickly respond to the representations received. As we already mentioned, I do have Ian Knight here with me, and he's the applicant's regional manager in case there are any operational questions. Chair, you have confirmed, I think, and I think David has as well, that the written submissions that were sent out in advance, the detailed submissions that painted the picture as to why we're here, they hopefully have been sent out and read by everybody. So, as you hopefully already know, this is an application by Wellington Pub Company, the freehold owner of the World's End pub, to restore the premises licence for the well-known property that has traded as a public house for centuries. Prior to considering the application, it is very important just to very quickly set out the context against which the application is made. The premises licence for these premises lapsed due to the bankruptcy of the previous tenant. Had the applicant known about it and submitted either an application for a transfer of the premises licence or an interim authority notice within 28 days of the bankruptcy, then the licence would still be in force and we would not be sat here today. The licence was not revoked, nor were there any serious complaints or difficulties at the time with the operation of the premises. It was lost due to an administrative failure to submit the correct paperwork within the statutory time frame. As soon as the applicant realised the administrative error had taken place, they started the process of submitting an application to relicense the property. This was of course delayed by the unfortunate incident of the squatters from I think February to July of this year. The new licence application was intended, as usual when this unfortunate situation does occasionally happen, was to mirror as closely as possible the licence hours and conditions that had lapsed. However, after detailed comprehensive consultation with the Noise and Nuisance Officer, the application was significantly amended to reduce the requested hours of operation and also to add a new condition regarding management of dispersal of patrons. The applicant is Wellington Pub Company plc. The company owns one of the largest free-of-type pub estates, circa 800 plus in the UK, as well as retail, restaurant, fast food, commercial premises. All these public houses are tenanted. My client does not run the pubs themselves. So as far as promoting the licensing objectives are concerned, Chair, the application contained numerous conditions covering all the expected things such as noise escape, CCTV, door supervisors, complaints, Challenge 25, plus a comprehensive dispersal policy as agreed with the Noise and Nuisance Officer. All of these, coupled with a significant reduction in hours, should hopefully alleviate the residents' fears. I won't talk about the conditions as such in my submissions, Chair, because I think what was being said that we might be looking at the conditions that the legal officer put forward yesterday. So I'll park the conditions if that's okay. As far as the issues raised in the representations, well, I'd ask you to consider the representations against the backdrop of the fact that there are no representations from any of the responsible authorities at all. The police did not object to the application, even in its original form. I'd also like to reiterate that a large part of the residents' objections related to the later kind of nightclub hours that they had seen previously, that were found on the previous premises licence. They do not want a licence in the same form as the previous one with the same hours. As has been mentioned already, and in the written submissions, these hours have been reduced significantly back down to normal pub hours. So this hopefully should no longer be an issue for the residents. It is also important to highlight the fact that the only complaints of noise made to the council in the last 2 years were made when the premises were not operating as a licensed premises, but were occupied by squatters. However, the newly agreed dispersal and external management plan conditions, plus all the other conditions, hopefully should ensure that no noise or nuisance will affect local residents going forward, especially with this significantly reduced hours. A number of residents have also highlighted the building, in their opinion, looking shabby and litter, etc. Well, of course, you know, money will be invested in the site. The tenants, when the tenant comes on board, are made to look make the property look good again. And obviously, once we have the tenants on board, I would love to think that the property will be restored to its former glory. I'll just very quickly sum up as part of my 10 minutes, Chair, if that's okay. Section 9.43 of the 182 Home Office Guidance states that an authority's determination should be evidence-based. This was highlighted in the well-known High Court case of Thwaite. So what is the evidence? Well, no objections from the experts and the primary sources of guidance in crime, disorder, noise and nuisance, i.e. the police and the environmental health and noise and nuisance officer. Surely if there were any concerns about the premises or the immediate area, these officers would have objected and would be sat here today. This fact should, I respectfully consider, this fact should carry considerable weight when determining its application. As we have already seen, there are detailed conditions on the licence application, and we have a further agreed one with the noise and nuisance officer, plus the additional conditions that we can agree to today. We have a very long established famous premises whose licence has lapsed, but not because of any issues. It was lapsed due to a procedural failure only. The majority of the objectors are happy to have this pub relicensed, but not at the much later hours seen on the lapsed licence. As we have highlighted already, we have amended the application to give them what they wanted. I'll finish up by reminding the committee this is not a review hearing. In fact, we would not be sat here today if a simple form had been filled out previously. I would remind the residents, if they were here today, that in the future, if the operation of the pub is not meeting the licensing objectives, anyone is free to apply for review of the premises licence. It is their right under the Licensing Act. I conclude by thanking the committee for its time, and in light of what we've heard today, I respectfully invite the committee to grant the application and give the community their pub back. Thank you.
Thank you. Now, any questions from the committee? Councillor Rossi?
Yes, first of all, I'd like to thank you to agreeing to lessening the hours, because I think that actually addresses one of the biggest problems. But you do say, I'd like to take you to task on one thing. You say that there were no complaints and nothing from the responsible authorities. In fact, there was an item, an email from the noise and nuisance people, Matt McIlroy, who made a representation about public nuisance and licensing objectives. So what I'm saying is this, that we have that, which did come from our noise nuisance people, and having read through all of the objections to this, two things I'd like to say. Number one, there have been objections and there have been complaints about how the premises was run in the past. Secondly, to say, and that's it, they have, noise and nuisance have agreed, have suggested the reduction of hours, you have agreed to it. Most of the objections actually are about the disco hours and not as the Wales End pub running as a pub. So what I'm just trying to correct is the way it was run in the past has caused problems, but you seem to have addressed that, and so hopefully going forward with pub hours, the residents will not be unduly disturbed. Thank you.
Councillor Benton?
Nothing, Chair.
No. I actually do have a question. I was wondering, we have had situations with squatters before, and management has gotten involved and put up a guard outside so that there wouldn't be. Why did it take you so long to know about the squatters, and what did you actually do about it?
If it's okay with you, Chair, I'll pass you over to Ian. He knows more about the operational situation with the squatters to answer that question. Thank you.
We actually found out about the squatters very quickly. There was already security in place. There are cameras inside the building, and there are shutters on the internal windows. We can't put them externally on this particular property because it's Grade 2 listed. So as soon as the squatters were into the property, the police were phoned. The police came along to the property, and they couldn't find evidence at the time of the property having been broken and entered into. That became apparent later from footage that the security company provided, but it was too late by that stage, and the squatters had basically claimed their rights to stay in the property. They weren't willing to move on freely, and so we instructed Goschalks, a different team there, to try and remove the squatters as soon as possible to get the consent from the court to do that. However, at the time, there was a lot of pressure on the courts with other matters of government policy, which held up the case going to court for months and months. So we tried to push it ahead as quickly as we could, but the courts just didn't have the capacity to actually hear the case and then give the notice that we required to then evict the squatters. So we did remove them as soon as we could do.
Thank you. And can you tell me what sort of tenant are you looking for?
We ideally, we've been in discussions with tenants, and there are a number of parties who are experienced operators, which would be our preference, who run a number of central London venues that are similar, where there would be a good mix of a restaurant type offer, but allied to sort of a pub type use as well. So probably gastro pub, it looks like the most likely sort of solution for the property.
And how many square feet is the premises? I'm glad you couldn't read those diagrams, because we couldn't either.
I don't have that information. I don't know if you do.
I mean, the premises itself is over 5 floors, but there's 3 trading floors. In total, in square feet, it's probably about sort of 6,500 to 7,000 of trading space.
Okay, thank you. Now, any questions from our legal officer?
Thank you. Just 2 questions. Is there a pub garden? Obviously, is there like an external area?
There's an external area which has been used by the previous occupant. It's not included in the demise of the property. It's outside on the pavement, and it was used by way of the grant of a pavement licence from the local authority. There is, at first floor level, a small roof terrace area as well, but that's at the back of the property overlooking the garden centre.
So there's no residential properties directly behind?
No.
Okay, so garden. All right, so there's no pub garden, but there's, on the King's Road frontage, are you talking about where the pavement licence was?
The pavement licence was actually to the, if you look at the property from the King's Road, it was to the right-hand side, because there's a open area in front of the theatre, and it was sort of as you entered into that open square, there was an area under the trees on the right-hand side.
Okay, so it's on highway. Okay. I think most of the questions will come from the conditions. I think just one other thing I know the Fire Authority haven't put in a representation, and I know it's not conditionable. Just out of interest, what is the capacity of the 3 floors that when they're at full capacity?
I can't tell you that exactly.
Okay. I think that's it for questions for me for now.
Thank you. Do you want to deal with the draft conditions? Yeah.
You've obviously received the draft conditions that were circulated last night. I've just tweaked some of them so they're more in line with our standard wording. If I just go through the numbers, and if you tell me if there's anything you wish to raise as an issue.
Yeah, as a whole, we're very happy with the amendments you made. Just a couple of tweaks here and there, so we'll jump in at your convenience. If that's okay.
So number 1, just say okay, or number 1 okay?
Yeah, it's okay.
2, 3, 4, 5, 6.
Yes, fine.
Are you okay with our amended CCTV and signage condition? Number 7.
Yeah, I mean, it's very comprehensive, but I'd like to think that any respectable operator shouldn't have a problem with that.
Yeah, that's our standard one. Number 8, I was getting a bit confused with the wording, and I was trying to work out what floors, how many. If you could explain that, that would be helpful, please.
I'll be honest, this is the condition that concerned me the most, only because it's the historical condition that we had on the licence when it was being used as a 2 AM licence. I'll give you an example as to why kind of this condition, I think probably once the hours had been reduced, we probably should have requested this condition to be amended as well, because, you know, for example, the upstairs floor is used as a steak restaurant. And if hypothetically the upstairs is used as, say, a restaurant,
okay.
The way that this previous condition is worded, we could have door staff on the door of the restaurant and walking around the restaurant on our I mean, it just doesn't make sense because of the nature of the potential operation. So I think my microphone's going on and off, so apologies for that. So yeah, that was the only concern, was this historical condition. It starts off fine and says, obviously, a minimum of 1 SIA registered door supervisor shall be on duty at the premises Thursday to Saturday from 7 PM until 30 minutes after the premises closes and the last customers have left. We have no problem with that part. My concern is the next bit. I don't know, and obviously it's subject to you good self and the committee, but whether we could put some additional wording in and remove the next paragraph that talks about all these floors, having people walking around on these different floors as if they were being used as nightclubs and things. We could potentially have some wording that says, for example, the number of door staff on duty and their location/duties will be covered by a risk assessment carried out by the DPS/licence holder. So we have a minimum 1 SIA door supervisor on duty from Thursday to Saturday, as we have worded here, but we don't have this confusing situation where if one room is open, we might have additional door staff stood on the door and on the back door, because potentially it could just be a normal pub or a restaurant, for example. I don't know what your thoughts are on that.
So you've got the basement, ground floor, first floor, and you're talking about rear entrances and front. Which sort of, so the ground floor presumably has a front entrance and a rear entrance? And what about the other floors?
All of the other floors have to go in and out of the same 2 entrances unless going out of a fire exit.
Okay. And obviously at this stage you don't know what the basement and the first floor is going to be used for. I think one thing that obviously we need to be mindful of what's been advertised, etc. I think one thing that in relation to, I don't know what the committee's thoughts are, this is just me thinking out loud. You said there's like a roof terrace on the first floor, but obviously it overlooks a garden centre, so there hasn't been any, that we're aware of, any historical noise complaints in relation to that. So maybe that's not an issue. I'm just trying to think on my feet. And then you're suggesting just risk assess, so have the first paragraph, but then risk assess whether further door staff are required for the other floors.
Absolutely. Once the operator who's in knows what needs to be done for the premises that they're using, I mean, I'll quote you and you'll know this, but Section 182, 10.10, licensing conditions should be tailored to the size, type, location and activities taking place at the premises. So I guess a licensing condition that talks about having potentially 4 or 5 door staff in a premise that could potentially be a restaurant is just kind of, with respect, it would just be kind of so operationally challenging and restrictive for any future operator to comply with. Yeah, understandable as to why the condition was there previously when they had this late night license, but if it's going to be, say, hypothetically a gastropub, it would be unreasonable to have 4 or 5 door staff members walking around.
Yeah, that makes sense. Okay, I mean, the committee can go ahead and think about that, but it makes sense what you're saying. Thank you. Right, number 9, you okay with that?
Yes, thank you.
10?
Yep.
11?
Yes.
12?
Yep, no problem with 12.
13?
It's very comprehensive, but yes, again, it's not restrictive.
14?
I do have, and I think it's an obvious query about this one, external doors and windows during licensable activities, so basically every minute of every day that the premises is open. Is there any chance we could change licensable activities to regulated entertainment? I'm just thinking if this is about a noise escape.
Yes, because obviously you're applying for live music and recorded music, so obviously if it's not incidental, if it's live or recorded, then perhaps that will be more suitable. I don't know if Mr. Williams has got anything to say on that.
What I would say is unregulated until 2300 hours anyway, so we wouldn't be able to enforce anything with that.
It's for 1 hour, perhaps. Okay.
Yeah, perhaps you could put a time limit on the time the doors and windows should be open from 2200 hours or something like that.
Oh, closed from 2200 hours, yeah. Any views on that?
If that during regulated entertainment, yeah.
Sorry, say that again?
Is that during any regulated entertainment? If regulated entertainment is taking place, the windows and doors will be closed after 10 p.m.
Dave, are you talking about regulated entertainment or anyway, or regardless?
No, I would go for regulated entertainments because the normal alcohol sales, etc., shouldn't cause noise issues.
Okay, so you're asking for all doors and windows to be shut from 10 p.m. until close when regulated entertainment is taking place?
Just suggesting. I'm not asking. I didn't make a rep, so.
Okay. You all right with that? Okay. Number 15.
Yeah, that's fine.
16 is the one you've agreed with.
Yeah, correct, no problem with that.
And then these are just additional ones which are pretty standard on most licenses, but we're missing from your license. Staff training, number 17.
Yeah, that's fine.
Refuse collections, I noticed that was missing.
Well, yeah, the only thing I'd say, and this is, I guess, an obvious one, is I don't know what the public refuse collection is. I mean, we can't govern when a public refuse collection comes and collects their refuse. If it's private, then we can be held responsible. But if the bin men come at a certain time, then they come at a certain time. So I don't know what you think about that one, Lindsay, as to whether we can have a condition that says that the bin men won't come at a certain time.
Okay, so I think I've probably got some precedent wording elsewhere which kind of caters for the situation where you're worried that it won't fall within the 23 to 7.
We can't do anything about it, can we?
Yeah.
If they come when they come, we can't tell the council when they're going to collect their bins. So if it's private deliveries, private things, us putting the bottles out, yes, absolutely, we can have a condition because that's something that's reasonable and we're in control of. But I don't think we can have a condition that controls when the council's refuse collections take place.
Okay, I'll go away and look at the other conditions.
Okay.
Sorry. Yeah. Yeah, I think he's just worried if it's out with those hours. Yeah. Okay. Number 19.
If we had a premise here that was, in a residential, I did one last week in a massive residential housing estate, and it was the only pub for miles, and there was about 5,000 houses, and I think we offered up a residents meeting there because there were zillions of residents surrounding this one commercial premise. I'm not sure whether to condition a compulsory twice yearly residents association meeting is reasonable, but we're not going to fall out over this, Lindsay, if you insist as a committee. In the circumstances, I'm just going to highlight the fact that the majority of the issues were during the late hours that are not going to be an issue, and during the squatter time, etc. So I'm just not convinced that to condition it would be reasonable, but I'm in your hands.
Excuse me, I mean, it's... Yeah, I think the conditions basically, it's basically you're reaching out, and then if they don't want it, you know, unless it's previously agreed in writing, then you don't have to do it. So I think it's just a way that the residents, I mean, all we're asking is you directly notify the ward councillors and that one residents association. If those, I think, though, if those persons don't want a meeting, then you don't have to have a meeting.
That's fine. We will reach out as per the condition.
Thank you. Number 20.
I think we don't need that anymore now, maybe, potentially, Lindsay, with what we've discussed about door staff previously, because there will be a member of door staff already on that period, for that period, potentially covering this.
Okay. (21)
No problem with this at all. The only question I'm going to raise here, and apologies, I'm not an expert when it comes to SIA walkie-talkie communication, but I just wonder whether that second paragraph could potentially be removed, especially with the nature of the premises of what it's hopefully going to be. I don't think, you know, a senior manager of a gastropub is going to have an earpiece in running around with a walkie-talkie being connected to his door supervisors potentially. So I just wonder whether in the circumstances we can keep the first paragraph and the last paragraph but remove the middle one, Lindsay, if that's okay.
Or how about if you're on one of the nights where you've risk assessed that more than one SIA is needed, how about on nights where there's 2 or more SIA, then those between themselves they'll need it?
I'm just curious to know, and I don't know, Ian, if you know about door staff walkie-talkies. I just don't know if this thing does exist. I don't know if management do have the ability, normally do they, to have an earpiece into their walkie-talkies of the door staff?
Speak.
I think the issue really is how many floors are in operation. If you have someone on the ground and someone on the 5th floor, they need to communicate if there's an issue. But usually they do have an earpiece of some sort.
It's difficult. If that is something that is common, Chair, you know, and if there is something, I'm not a techie person, but if this is something where the management can be in contact with a walkie-talkie or earpieces to the door staff, if that is something that exists and is common, then okay, I just wonder whether as a condition to insist that the manager of a gastropub has direct earpiece communication with a walkie-talkie to his door staff. I just don't know if that's
Could even be a WhatsApp group, so maybe we can make it more general, that there has to be an ability to communicate.
Yeah, I think it's just about, obviously, where there's, obviously on the nights that you've got other floors open, it's just so that they can communicate with each other. Maybe not necessarily I mean, I don't know if Mr. Williams has got any comments in this regard, but it's just so that there's lines of communication open between the SIAs and managers. If you're going to hold an event or something.
Yeah, in my experience, it's just larger establishments, i.e. nightclubs, etc., that would have a two-way radio system. But that said, the ability to communicate somehow with your manager, they've got to have one, whether it be by phone or whatever.
I guess they would communicate because they are their door staff. You know, the management will have lines of communication with their own door staff. It's just a question of whether that is a condition thing stating that they will be provided with a radio as the means of that communication, because they will, of course, communicate with their own door staff because it's vitally important that they know what's happening.
Okay, we'll go away and have a think about that one. Last one, number 22.
Absolutely fine, Lindsay, no problem at all.
Right, I don't think there's any other conditions that have cropped up. Any of you conditions that you think needs to be conditioned?
Do our licensing officers have anything to add?
No further comments. Thank you, Chair.
Thank you. And our governance officers, anything to add?
Nothing, thank you, Madam Chairman.
Thank you. We have reached the end of our meeting. The committee now has all the information needed, and we will retire to make our decision in private session. We will not announce the decision today. Instead, the hearing will be closed. A summary determination will be sent to the parties within 5 working days of today's hearing, hopefully by Christmas Eve. And a full decision will follow as soon as possible thereafter. The time limit for appealing the decision will not commence until the full decision has been sent to the parties. Thank you all for attending. The hearing is now closed, and I wish you a Merry Christmas.
Thank you, Chair. Merry Christmas to you all. Thank you for your time today. Thank you.